Hello and welcome to the Dependency section of the ULV Justice Center website. Glad to have you. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise that you consult with an attorney. In this video, we will be discussing what dependency means, what dependency cases are like in general, what to expect in court, the burden of proof that the county will need to prove its case, as well as reunification plans. Dependency cases begin when there is suspected abuse or neglect of a child, or someone believes a child is in danger of potential abuse or neglect. Dependency cases are under the jurisdiction of the juvenile court system because they deal with the care of minors. Until the age of 18, a minor is dependent on adults in charge of their care to meet their basic needs and for protection. If the court feels that the needs of the child are not being met, the juvenile court will step in and either provide the parents with the resources or training they need to better protect their children. In extreme cases, the courts may decide to remove the child from the home temporarily or permanently, in which case the child becomes a dependent of the court. A dependency case will begin when there is a report of suspected abuse or neglect or potential abuse or neglect of a child made to Child Protective Services or the police. These entities have an obligation to investigate these reports. The social worker will conduct their investigation to confirm these allegations and concerns that the parent is not properly caring for the child or the child is not being protected from the abuse of someone else. The investigation will include the social worker speaking with the parent, the child, and people who are close to the situation, such as family and neighbors. The social worker has the right to speak to the child at the school without the parent present, and the parent will be notified after the interview has been conducted. Once a social worker has completed their investigation of the case, they may take no action because there was no evidence of abuse or neglect. They may offer voluntary services. These are free services that will teach the parent how to develop necessary skills to parent the child in a safer way. The social worker may file a petition with the court and the child may remain in the parent's care. Lastly, the social worker may remove the child from the home and file a petition with the court. The child may be placed with a relative, foster care, or with their other parent if their parents are separated. If the social worker decides to file a petition, the petition will be filed within 2 days of removing the child from the home and there will be an open case in juvenile court. The hearing will be held by the end of day after the petition was filed if the child was removed from the parent's care. The first hearing will be no later than 15 days after the petition was filed if the child remains in the parent's care. At the initial hearing, also called the detention hearing if the child was removed from the home, the child will be provided with an attorney to represent them. If the parent cannot afford an attorney, one will be appointed to them as well. The judge ordered to preside over the case will review the social worker's petition and report. These will contain all of the reasons provided by the social worker about what they believe is happening to the child under the care of their parent. This hearing is similar to an arraignment hearing in criminal court cases. It will be a relatively short court appearance, while nothing will really change or be evaluated. This is just to determine where the child should stay until the next hearing. The child will either remain in the parent's care, be returned to the parent's care, or remain removed from the home until the next meeting. At the jurisdictional hearing, the judge will determine if the alleged abuse and neglect claims are true. The parent has the option of admitting, not disagreeing with, also called submission, or disputing the petition, also called contesting. An admission or submission of the petition forfeits or waives the parent's right to a trial. If the parent decides to contest the petition, the county will present the court with the evidence and witnesses it has produced to meet their burden of proof. The parent will also have the opportunity to present evidence, witnesses, and testify to argue that the petition's allegations are false. If the abuse is found to be untrue because the county has failed to meet its burden of proof, the case will be dismissed. The Welfare and Institution Code Section 300 provides a criteria that must be met for the county to prove the abuse or neglect allegations. It also provides the juvenile court with the authority to have jurisdiction over a child. The county will have to prove the elements of at least one subsection of Code Section 300 through clear and convincing evidence. This burden of proof is the second highest in our legal system, below reasonable doubt, which is only used in criminal cases. Clear and convincing evidence means that the evidence is so clear it leaves no room for substantial doubt. If the allegations of the petition are found true through evidence presented by the county, the child will become a dependent of the court. This means that the judge has the authority to make decisions about the care of the child. If the allegations made in the petition and report are found to be true, the disposition hearing will provide a plan to rectify the issues found by the court called a reunification plan. This plan will include things like where the child should live, reunification services, and what can be done for the child for them to become safe and healthy. The court will not allow a parent to participate in reunification services If the child or a sibling has previously been abused or killed, the parent has previously had another child become a dependent of the court, the parent ever had reunification services terminated for another child, or the parent has a serious, untreated substance abuse problem. Once the reunification plans are set up with the social worker and the attorney, the parent must begin completing these services as soon as possible. If the child is under the age of 3, there is a 6-month deadline for the parent to prove to the court that they are completing the reunification plan. If the child is over the age of 3, the deadline is 1 year. If the parent decides not to participate in the reunification plan, the court may decide to terminate the plan. This will lead to the court focusing on finding a permanent home for the child that is not with the parent. The next hearing to review progress will be held in 6 months. The review hearings are scheduled every 6 months to monitor the progress of the reunification plan. The hearing will include an assessment and report put together by the county for recommendation on how the case should continue moving forward. The assessment and report will include things like how the child is doing physically and mentally, as well as how the parents are progressing in the reunification plan. The attorney for both the parent and child will be given the opportunity to present their arguments for why the recommendation is the proper way to continue in the process. A judge will make a ruling based on the arguments presented. These hearings are important because the judge may decide to expedite the plan and return the child to the care of their parent. They may decide to keep the child out of the parent's care and provide a 6-month extension to show progress, or order the child to remain out of the parent's care and terminate reunification services. The review hearings will continue to be held every 6 months until the parent has proven to be a suitable parent by the completion of the reunification plan, or the court decides to permanently terminate the parent's custody of the child. This has been an overview of the dependency section of law. On behalf of the ULV Justice Center, we thank you for your time and hope that this information is helpful in your legal matter.